Everyone, and thank you so much for joining us today for our webinar. Today we're talking about environmental assessment. Environmental assessment is not red tape, a primer on recent changes in Ontario. My name is April Wepler, and I'm the engagement coordinator for the Healthy Great Lakes program at the Canadian Environmental Law Association, or CELA. And a number of my colleagues from CELA are on the line today. I'll introduce you to them momentarily. Before I tell you more about our webinar today, I'd like to acknowledge that I'm calling in today from Guelph, which is situated on the ancestral homelands of the Anishinaabeg peoples, specifically the traditional territory of the Mississaugas of the Credit First Nation, and our neighbors are the Six Nations of the Grand Watershed. Tell you a little bit more about CELA for those who might not be familiar with our work. We are a specialty legal clinic within the Ontario-wide network of clinics funded by Legal Aid Ontario. We work to protect human health and our environment by seeking justice for those harmed by pollution and working to change policies to prevent those problems in the first place. Our work CELA's work for environmental law protection and reform is fundamental to social justice because the people most impacted by air pollution, unsafe water, or contaminated land are often least able to avoid such threats. This year, CELA is celebrating our 50th anniversary, and we can't let down our guard. Environmental laws are under attack in Ontario, and even the Ontario legal aid system itself has been threatened with ill-advised reform ideas over the last year. We hope you will want to stay engaged with CELA, pay attention to these issues, and speak out for the most vulnerable among us, and call for strong environmental protection laws and to support our work. We suggest that you check out our website. We'll be posting that link later in the webinar, and also sign up for our newsletter so you can learn more about these types of opportunities. I want to do a quick little bit of housekeeping for those who may be new to Zoom. All of our participants today are in listen-only mode, so your video and your microphones are turned off. We have over 100 people on the line already, with more joining, so we do that to protect the quality of the recording and to ensure a strong session for everyone today with good, clear sound. We are recording the session today, and that recording will be sent out to everyone who's registered and also posted on our website, so you'll have access to that after the session. We've also disabled the chat function, you will have noticed, and you don't need to use the hand raising feature. We're going to do all of our questions today through the Q&A box. So if you scroll your mouse over the bottom of your Zoom window, you'll see that Q&A icon pop up, and you can put your questions in anytime. At the end of Rick and Carrie's presentations, we'll take as many of those questions as we have time for. Just before I hand the mic over to my colleagues, I want to do just two quick polling questions to get a sense of who we have on the line today. So for those who are listening to our session over your computer, you're going to see a poll question pop up. And we're just asking you to tell us what sector you represent. For those who've joined our sessions before, you're old hand at this. I'm just going to leave that open for another few seconds. You can see lots of responses coming in. Great. And I'll show you who's on the line so you can see who's joining us. So not surprisingly, more than half of people on the line today are with an environmental organization, and then also some academics, students, some government representatives, a couple of media, and then a whole bunch of others. Curious to know who else is on the line with us. Second question that we just want to ask you to get a sense of the amount of knowledge on the call already for our speakers is, how would you rate your knowledge about environmental assessment law in Ontario? Just going to leave that open for a few seconds. This is helpful for Rick and Carrie to get a sense of whether you're all experts already. All right, leave that up for another second. And show this back. Great. So that's really helpful for us to know that a fair bit of knowledge on the line already, but lots of complexity for us to talk about today, for sure. All right, with that, I will introduce my two colleagues who are on the line. Rick Lindgren is counsel with the Canadian Environmental Law Association, and Carrie Blaze is our Northern Services Counsel. And first up today is Carrie, so I will pass the virtual mic over to you, Carrie.
Thank you, April, and welcome everyone who's joined us online for today's webinar. Just a quick disclaimer that this presentation does contain legal information, but it should not be construed as legal advice. And so if you do need legal advice specific to the circumstances of an environmental assessment, we do ask that you contact competent legal counsel. So today's webinar will be in two parts. I'm going to begin by reviewing Bill 197 and Ontario's Environmental Assessment Act. And I'll also look at key changes that have happened to Ontario's EA Act, both before and after Bill 197. And I hope to close with noting a few possibilities of what's next and where do law reform opportunities remain. Following my presentation, it'll take about 20 minutes. Rick will then discuss the proposed list of projects that will now trigger comprehensive EAs under the EA Act. So let's begin. What is Bill 197? So in July, a significant and lengthy piece of legislation was tabled, known as the COVID-19 Economic Recovery Act. The bill contained 20 schedules and proposed amendments to over 11 laws that directly affect the health of our communities and the environment by changing and amending provisions within the Environmental Assessment Act, the Planning Act, the Drainage Act, the Building Code Act, to name a few. While the stated aim of the bill was pandemic recovery, it advanced other purposes, namely environmental deregulation. And it altogether failed to respond to the public's call to action for a green recovery in order to confront the twin crises of climate change and biodiversity loss. Today, we're going to review the changes which are specific to environmental assessment law. And we're holding this webinar to review the sweeping changes to the Environmental Assessment Act here in Ontario, which end long-standing public safeguards which are designed to protect the environment and our health. And as my colleague Rick will discuss next, there's a deadline for comments, which is coming up in November. And so we hope today's webinar will inform you in making those comments. We also wish to note that within 2 weeks of the bill being passed, being introduced, it was passed. So there was no public consultation on the bill prior to its passing, and the province ignored the legal requirement that is set out in the Environmental Bill of Rights, which requires that they give notice of a proposed law to the public and provide a minimum 30 days to provide comments. Perhaps many of you joining us have consulted on prior environmental assessment matters, including the ministry's discussion paper from April of 2019, where they sought to modernize the EA process, or perhaps it was the November 2018 Environment Plan, which also discussed environmental assessment in Ontario. However, these contained only high-level conceptual discussions and broad vision statements, and they did not contain committal policy suggestions such as those we see in Bill 197. Passing the bill absent due regard for the public's right to participate is particularly detrimental given its serious and alarming impacts for Ontarians. Not only does Bill 197 restrict the applicability of EA processes to new projects and developments, but it also increases the uncertainty about how new projects will be reviewed. So specifically, we're reviewing Schedule 6, which amends Ontario's Environmental Assessment Act. So the EA Act, or the EAA, is one of Ontario's oldest and most important environmental laws. It was groundbreaking legislation when it was first enacted in 1975, as it established a new environmental planning process to ensure an integrated consideration at an early stage of the entire complex range of environmental effects which may be generated by a project. The EA Act remains a critical environmental law, but Ontario's attempt at modernizing the Act has not made it more effective, efficient, or equitable. With Bill 197 now enacted, Ontario has indicated that the suite of changes that are proposed to come into force will come out in 3 stages. So let's begin. So EA is a look before you leap law. It requires upfront public examination of ecological, socioeconomic, and cultural impacts of a proposed project. And that's what makes EA so critical, is that they canvass these fundamental factors of a project prior to approval or development. By nature, EA requires a more holistic and comprehensive review of key matters such as the need for the project, alternatives to the project, And these considerations are not part of other regulatory environmental laws. And at its core, the EA includes the involvement of individuals, the public, and directly affected communities in decision-making by providing them an opportunity to weigh in on the project and, again, its purpose, its needs, potential alternatives. This purpose is emulated in the statement purpose of Ontario's EA Act, with the statutory purpose being the betterment of Ontarians by providing for the protection, conservation, and wise management of the environment. So in order to review the key changes that were made to the EA Act, I want to quickly reference a few aspects that existed prior to Bill 197. So first, the EA Act was applicable to all public sector undertakings, so activities, programs, proposals, plans, unless they were specifically exempted, and it applied to private sector undertakings that were designated as major. Second, prior to Bill 197, the Act set out whether, and if so how, classes of activities may be subject to a specific environmental assessment regime that governs how all the activities within that class or group would be carried out. These were known as Class EAs. And to name a few, Ontario had approved Class EAs for water power projects, municipal infrastructure, provincial parks, forest management. Lastly, the EA Act prior to Bill 197 also set out when a Class EA could be subject to an individual or a full environmental assessment, and these were commonly referred to as bump up requests. So now moving to the key changes we see in the EA Act. Bill 197 removed the automatic application of the Act to public sector undertakings, and it's being replaced by Cabinet having unfettered discretion to pass a new regulation which lists which projects will or will not be subject to the Act. Also note the change in language where undertakings have now become projects. So this is a radical departure from the former application of the EA Act. The introduction of a new Section 3, which authorizes the passage of a regulation that prescribes what types of projects will be subject to the EA Act, will result ultimately in fewer projects undergoing an EA. So while the designation of projects is intended to include ancillary projects, we don't know how this will be defined as it's been deferred to a future regulation. Furthermore, the amendments contained in Bill 197 do not specify criteria or thresholds for identifying which undertakings will or will not be included in the project list. And while the government's apparent intention was to focus the EA Act and its amendments on projects that have the most potential to impact the environment, this objective is not found in the new Section 3 of the Act. So ultimately, a listing approach, it ignores the fact that the nature, the extent, the frequency and magnitude and duration of environmental harm is greatly dependent on the site-specific location, technology choices, the design and operating specifications for that project. So until an individual project is proposed at an actual location, it's difficult to predetermine the significance of the potential impacts in advance on a purely hypothetical basis. The amendments contained in Bill 197 also changed some names, which I alluded to earlier in the Act, and introduced some standardizations. So for instance, the individual EA process has now been renamed a comprehensive EA, under Part 2.3 of the EA Act. And for the most part, the existing provisions and the content around the conduct of an individual EA, now comprehensive EA, are essentially unchanged. And this includes, the ministerial scoping power to approve the EA terms of reference that exclude any of the important EA planning considerations listed in the new section 17.6 sub 2. And in light of the ministerial scoping power, and given the well-documented systemic problems that continue to militate against public or Indigenous participation in individual EA, processes, we remain highly concerned that the new comprehensive EA will not live up to its name. Furthermore, the Ontario government is proposing to expedite the preparation and approval of terms of reference by making regulations which set out standardized requirements that proponents can follow in certain sectors. However, the amendments do not identify which sectors will be subject to the standardization, and nor is there any prescriptive detail like the content of these generic terms of reference. So without this vital information, we remain unable to conclude whether the standardized terms of reference will be an improvement over project-specific terms of reference that are tailored to meet the potential environmental impacts or planning considerations that are raised by local residents, communities, or other stakeholders. So Schedule 6 of Bill 197 also terminated the currently approved Class EAs, and those will be replaced with a yet to be determined streamlined EA requirements, which will be set out by regulation. So the legal basis for Class EAs was established in the 1996 amendments to the EA Act, and various Class EAs have been developed since that time to provide planning, notification, and documentation requirements for certain infrastructure projects that are supposedly small scale, recur frequently, and have predictable impacts that may be amenable to known mitigation measures. So in essence, the current suite of approved Class EAs establishes a streamlined self-assessment procedure, which are typically less extensive than those required for the individual, now comprehensive EA process. Moreover, these Class EAs usually delineate different categories or levels of assessment for a project within the class of undertakings, depending on the nature of the project and the potential for environmental impacts. So despite our careful review of the new streamlined EA provisions, it's not clear whether the essential Class EA requirements will be fully replicated as the regulations on this matter are yet to be released. Another change contained in Schedule 6 of Bill 197 is that it significantly restricts the grounds upon which Ontarians can request a bump up or an elevation of a contentious project. So from a streamlined EA to a comprehensive EA. We have no objection to the proposal in the new sections 16 and 17.31 of the Act, which permit Indigenous communities to seek elevations of a Class EA to the more stringent individual EA. However, it is limited to that ground. And so we do strongly object to the prevention or disallowance of other residents of Ontario filing an elevation request or a bump up request. Even on this limited ground of filing a bump up request, if constrained to treaty and Aboriginal rights, the minister still retains discretion to grant or deny the elevation, and there's no improvements to this black box decision-making process. Lastly, there's no formal process yet defined that sets out how a member of the public can ask for the designation of a project. That's not listed. There's also new provisions in the Act regarding municipalities, and they've been given a greater say in landfill siting. And so while we generally agree with the new sections 6.0.1 and 17.5, provided in Schedule 6 that it now requires that landfill proponents obtain proof of municipal support from host municipalities and those within 3.5 kilometers of the site for proposed landfills, we have to remember that it's only the largest of landfills that are actually required to undergo an individual EA. And as proposed in the project list, which Rick will talk to in more detail soon, only landfills greater than 100,000 cubic meters of disposal capacity trigger an EA. And within these new provisions, the minister and or cabinet can still dispense with the municipal support requirements on a case-by-case basis. So for instance, if the Ministry of Environment was to believe that a particular landfill should proceed quickly due to a perceived environment or public health issue. I'd also like to flag that in addition to Schedule 6 of Bill 197, there was a number of other rollbacks that have been passed which affect EA in Ontario. And these include removing the EA requirement from forest management planning, exempting projects in all provincial parks and conservation reserves from any EA. Changes were also made streamlining EA requirements for certain provincial highways and transportation corridors. And there's also modifications to transit projects within the GTA. I'm not going to get into these changes, but I will point you to our website, cela.ca, where there are a number of blogs and resources specific to these changes. In closing, I think it's important to remember that this was a missed opportunity to act on a number of important improvements that are needed to the EA Act. So over the past 20 years, many commentators and stakeholders and independent officers of the Ontario legislature have identified numerous shortfalls of the EA Act and ways to improve them that are needed in order to bring the EA program into the 21st century. And to name just a few to pick up on my earlier points, in place of a project list, we need to ensure that all environmentally significant undertakings are reviewed in an open, fair, evidence-based process, regardless of the private-public distinction. And to remedy the shortfalls of the bump-up process, we need to implement the long-ago recommendation of the Environment Minister's EA Advisory Panel that found during the Class EA planning process, there should be an expedited mechanism so we can seek rulings or directions from the Environmental Review Tribunal. And if there was outstanding disputes at the end of the Class EA planning process, bump-up requests should be adjudicated in writing to the Environmental Review Tribunal. And lastly, there's a need to limit the minister's ability to approve the scope of a project's review in its terms of reference, which historically has unduly narrowed or excluded considerations about the project's purpose, its needs, and alternatives. And despite all of what has been said so far today and what is yet to come that Rick will share, there is still time to push back, as Ontario has indicated that in the coming months, a second list of proposed projects that will undergo streamlined EAs will be developed. And there's a suite of regulations that are not yet in place, but alluded to in the text of Bill 197. And this includes a regulation setting out these standardized work plans for standard terms of references, also definitions regarding the treatment of ancillary projects within an EA, and also regulations which may exempt proponents from any requirement under the EA Act. Where also projects that are currently exempt either by declaration orders will be revoked and replaced by the project list, and there's no guarantee that these projects will appear on the project list. All of this to flag that the reform is not yet done, it's not fully in place, and to stay tuned. And with that, I will now turn it over to my colleague Rick, who's going to review the proposed list of projects that is open for public consultation.
Thank you, Carrie. Good afternoon, everybody. I think I'm waiting for April to let me share my screen. I'll just see if that's enabled yet.
You should be able to go ahead and share, Rick.
Yep, it's coming right up. Okay, so again, thank you for joining us this afternoon on a fairly important, fairly timely topic. I know that Halloween is just around the corner, so I thought I'd focus on something really scary, namely Ontario's proposed project list. So here's the roadmap for my presentation this afternoon. First, we'll look at what is on the proposed list. I think you'll agree it's not a very awe-inspiring collection of projects. Secondly, we'll review some of CELA's main concerns about the proposed project list and the process used to come up with a list. Third, I'll outline some of the next steps in this regulatory proposal and describe how you can get involved. And then we'll finish off by opening things up for questions and hopefully some answers and hopefully some good, interesting dialogue. So without further ado, let's get into it. Now, as Carrie just described, Bill 197 has a number of problematic aspects in terms of environmental assessment reform. She highlighted a few of them. What I'm going to focus on is the key change in Bill 197, which fundamentally alters how the Environmental Assessment Act is going to be applied to projects in the future. As most of you will know, the Environmental Assessment Act has had this rather curious distinction between public sector undertakings and private sector undertakings. The general rule, as I've indicated here on the third bullet point, traditionally the Environmental Assessment Act has applied automatically to all public sector undertakings unless they've been exempted, and there have been lots of exemptions. But the Act was not generally applied to private sector undertakings unless they've been designated, and there have been a few designations over the years. So that was the how the Act was applied from about 1975 up until about a month ago. So under Bill 197, that traditional triggering mechanism has been radically changed. Bill 197 uses what we call the project list approach. And in effect, that means that only the project types that are designated on the regulatory list will actually be subject to the comprehensive environmental assessment requirements of Part 2.3 of the Environmental Assessment Act. Now, in its consultation materials on the project list, the Ontario government essentially says, don't worry, be happy. The requirements of Part 2.3 of the Act remain more or less intact. They'll still be applied, but just to these projects. I have to tell you, I am worried and I'm not happy. The status quo under Part 2.3 has not been very helpful in terms of the public interest in protecting health and protecting the environment. I would say most of the individual EAs that I've seen over the last couple of decades have not been comprehensive. They've not been robust. And that's because the Environment Minister has often approved EA terms of reference that scope out or screen out or exclude some very important environmental planning considerations, such as, is there actually a demonstrable public interest and need for this particular project? What are the alternatives to the project? What are the alternative methods of carrying out the project? Are there better or safer alternative sites for this kind of undertaking? Those kinds of important questions have been routinely screened out of most individual EAs that I've seen in the last 20, 25 years. And so I think that leaves them, as far less than comprehensive. I would go on further, but I think that's a topic for another webinar on another day. I should indicate here, just because a project is not on the project list right now, doesn't mean it might not be subject to some other form of EA. As I'll mention later on in my presentation, the Ontario government intends to consult on its proposed list of candidates for the streamlined EA process, which will be available under Bill 197, except we haven't seen those regulatory proposals yet, so we can't say with any certainty, what's going to be on that list. But if a project's not listed on the project list, if it's not caught by the streamlined EA regime, chances are it's not going to be subject to any EA at all. I do note, however, that the proponents still have the option to voluntarily agree to be covered by the EA Act. That sometimes happens. And it's also, I guess, theoretically possible for Cabinet to designate a non-listed project, and I'll get into that in a few moments as well. So let's focus on what's on the list. These are the projects that will trigger comprehensive environmental assessments. And I would say for the most part, as I indicate in the first bullet point, the projects on the list are already subject to Part 2 of the Environmental Assessment Act for the most part. So in my view, the proposed list does not really move the yardsticks down the field too far. In short, the list is largely restricted to big, large-scale physical works that are already caught by the Act. And I've put a few examples here. The Act proposes to include certain types of transmission lines and transformer stations, big hydroelectric facilities and other types of power generation facilities. But that's already the law. That already is the case for the most part under Ontario Regulation 11601. It has been the case for 20 years, so it's not much of a material change there, but perhaps I'll come back to that. The proposed list also includes certain waste management projects, again, big landfills, hazardous waste sites, certain thermal treatment sites. Again, I would call this waste disposal more than waste management, but again, those are already caught by Ontario Regulation 10107. So again, not much of a significant change. Some of the biggest things that were subject to EA are subject to EA under the Bill 197 regime. And I'll give you some examples of the thresholds. The list also includes a small number of what I would call transportation projects, provincial freeways, municipal expressways over a certain distance, as well as intra-provincial railways. The proposed list also includes a suggestion that major flood or erosion control projects may be caught by the project list. Although there's a lot of uncertainty, a lot of ambiguity about what major really means. So it's not clear to me what kinds of projects will be designated on the list or which ones will be left out. So that needs to be sorted out by the Ministry of the Environment. And then finally, and perhaps most surprisingly of all, the proposed list doesn't contain any mines and doesn't really contain a clear commitment to include any mines on the project list, which is a bit of a surprise because virtually every other Canadian jurisdiction, you know, the feds, the provinces, others include mines as the type of thing that will trigger EA requirements. In Ontario, sort of been at the trailing edge of that. There have been a couple of instances where mining proponents in Ontario have voluntarily brought themselves under the Act, but for the most part, Ontario has not routinely applied the Act to mining projects, big or small. And so what the proposal from the ministry does is it simply invites public feedback on whether mines should be included on the Ontario list for the first time ever. And if that's the question from the government, then my answer is clearly yes, mines can and should be included. And I say that because of the, you know, the sheer size and the nature of mining projects. I say that because of, you know, the risks to the environment and to human health posed by certain mining projects. I say that because of the long-term liabilities associated with the long-term management and storage of mining waste. And so those are just some of the reasons why mines can and should be included on the Ontario list. So I indicated to you, I wanted to provide some actual examples of projects and numerical thresholds that are used or that are being proposed on the list. And so, for example, the list includes new transmission lines that are 50 plus kilometers in length, and they have a, you know, a certain kilovolt capacity. Skipping down, Carrie's already mentioned this, newer expanded landfills that have more than 100,000 cubic meters of disposal volume. They're on the list. There's a proposal to include, you know, roadways that are 75 plus kilometers, newer extended intra-provincial, that means within Ontario, railways that are 50 kilometers plus. So those are some of the actual examples that the ministry is currently soliciting public feedback on. I guess one of my concerns is I'm not sure that, you know, for linear projects like roads or railways, I'm not sure the projected distance is the best measure of potential environmental impact or significance. And I often use a roadway example for this. Let's say you're constructing or you propose to construct a roadway of a certain length. If you're proposing to do it within an already urbanized area, there's going to be some environmental impacts, but chances are you're not going to be running into significant natural heritage. But if you take the same road, the same distance, and plunk it down into the rural countryside, where you're going to probably run into water crossings, significant wetlands, woodlands, species at risk, habitat, those kinds of things, all of a sudden the same road proposal has a lot different character, a lot different potential for environmental impact. And that's why, my view has always been, what dictates environmental significance or risk of harm is mostly the location and the design and the operation. It's not the mere distance per se. So I have a problem with some of these numerical thresholds. The other problem that I see is that when you start establishing artificial lines in the sand, you sometimes end up inadvertently facilitating what we call project splitting. So you might see roadways being proposed at 74 kilometers just to evade EA requirements, or you might see a provincial railway just under 49 kilometers so as to avoid provincial EA. That's the problem you get into potentially if you start trying to use some of these distance or production or capacity thresholds. So those are some of the examples of what the Ontario government says should be on the project list. And now you may be wondering, well, exactly how do they come up with those candidates? How do they come up with those thresholds? And I would say to you, that's an excellent question, but it's one that's hard to answer on the basis of the rather sparse consultation materials that have been released by the Environment Ministry so far. But the registry notice for this proposal tells us that the main intent of the list is to restrict the application of Part 2.3 of the Act to what I would call the biggest and the baddest projects, namely those projects that are deemed by the Ontario government to have the greatest potential impact on the environment. I guess in response, I would simply say that is a self-imposed policy constraint. It's not actually found in the Environmental Assessment Act. It's not in the purpose statement. It's not in the new statutory definition of project. And more importantly, as I mentioned a few times, the Ontario government has not disclosed any evidence, any compelling or cogent evidence that explains how it made its choices, or that it compares or contrasts the perceived environmental impacts of listed projects vis-a-vis non-listed projects. I would kind of summarize this by saying the government's essentially asking us to trust them in terms of their analysis of potential environmental significance. Another policy objective that's mentioned in the environmental registry is that the Ontario government wants to end what it calls duplication. I say that is a myth. There is no jurisdictional overlap or duplication between the Environmental Assessment Act and other provincial environmental laws. Simply put, no other provincial environmental laws do what the Environmental Assessment Act does in terms of assessing in a very public and open manner the perceived need for the project, the alternatives to the project, the alternative methods of carrying out the projects, the full range of social and economic and cultural and ecological impacts. Only the Environmental Assessment Act really does that in a fairly concerted and comprehensive way. The other laws do not. And I would say to you, that's not just my view or CELA's view, that's a view that's shared by the Auditor General of Ontario. And on that point, I commend you to her excellent 2016 annual report, which has a very good critique of Ontario's EA program. And this is one of the points that she makes, that there is no real overlap or duplication between environmental assessment and other forms of regulatory statutes. Another concern that we have is that the Ontario government in its consultation materials suggests that it used its experience to apply certain environmental factors, the ones that I've listed in the first bullet point, the magnitude, duration, extent, frequency of perceived impacts in order to inform the content of the list. In my view, this claim is dubious at best, and I say that with all due respect, but the bottom line is as far as we know, the Ontario government has presented no evidence, has presented no scientific or technical reviews that substantiate its conclusions about what is or what is not significant enough to go on the list. That's why I say in the slide, it's our view that, based on the materials available to the public so far, the listing exercise simply is not credible, it's not accountable, it's not transparent. Now, as I have indicated, if those factors, those environmental factors have been rigorously applied by the ministry, at the very minimum, mines should have been and could have been identified as candidates for the list from the get-go, but they are not. And I would say the same thing about other environmentally significant activities or facilities that have also been excluded from the list. I'll come to a few examples in a moment. But again, it's kind of mystifying as to why certain things got left off the list with essentially no explanation. Now, with respect to mines, the Ontario consultation materials did say that they want to bring the Ontario regime into alignment with the federal regime, and the federal project the federal project list under the Impact Assessment Act does designate a number of mines for the purposes of federal environmental assessment. So it's not clear to me, whether Ontario intends to duplicate those thresholds or modify them. I think one of the concerns is some of the federal thresholds for mines are kind of set too high. For example, in relation to certain metal mines, only mines with greater than 5,000 tons per day production capacity are actually caught. Anything below that doesn't trigger federal EA. So CELA and a number of other groups have taken the position that even the federal thresholds have been set too high, and some groups have taken the position that virtually every mine and every mill should be caught for the purposes of environmental assessment. And again, if you start trying to divvy up types of mines by production thresholds, again, you're going to likely encourage some project splitting or some piecemealing. So people just conveniently fall under the threshold so they don't have to do EA. And we'll speed things up here a little bit so we have some time for discussion. I've just mentioned some of the things that the Ontario government is proposing to do and proposing to apply in terms of compiling the list. Interestingly enough, at the same time, the ministry does not appear to have considered certain factors that by law it's compelled to consider when they're drafting regulatory proposals. And I'm referring here to the Environmental Bill of Rights, EBR. And as many of you know, the Environment Ministry has a statement of environmental values under the EBR that has a number of really important environmental principles, and I've included a few of them in this slide. Precautionary principle, cumulative effects analysis, ecosystem approach. The problem that I see is that nowhere in the proposed list or in the consultation materials are these SEV requirements discussed or even mentioned, even though I think they're highly relevant in terms of trying to determine what goes on the list or what stays off the list. And from my perspective, that's another reason to be wary of the list and the process used to develop it. So the other exclusion that we're quite concerned about is the deliberate omission of provincial plans or programs, things like long-term energy plans, climate change plans, provincial land use plans. Those kinds of undertakings do appear to fall within the scope of the new definition of project, although the ministry's consultation materials confirm that they've deliberately not included any of those things on the project list, which is a rather startling omission, particularly in light of, again, the Auditor General's 2016 report, which reminds all of us that some of these large-scale plans are actually more environmentally significant and affect greater numbers of people than individual projects. And that's why, EA practitioners for decades have been advocating the need to not only look at the environmental effects of proposed projects, but we need to go up the pipe, so to speak, and look at some of the overarching governmental plans and programs that are driving some of these projects at the local level. And yet none of those things have made their way onto the project list. The other thing that hasn't been included are the various types of physical works and activities that by any objective standard are environmentally significant. And I've put a few here: sewage treatment plants, quarries, refineries, smelters, pulp and paper mills, chemical manufacturing. We can think, I think, pretty easily about the types of industrial or commercial or institutional activities that are significant and probably should go on to the list, but for whatever reason, they're not on the list. And why that is, I don't really know, because there's no explanation in the consultation materials. So that brings me to my conclusion about the proposed list. I don't think it's adequate. I think it's incomplete. It's based on stale dated thresholds, and it just leaves out way too many environmentally significant undertakings. And I think that point is amply demonstrated when you compare the provincial list to the federal project list. The Ontario list so far only includes 13 project types. The Ontario government can only think of 13 types of projects that warrant environmental assessment. And in comparison, the feds have identified 61 project types that are in their regulatory list. As well, the Act expressly includes some power that enables the minister to designate non-listed projects on public request. So, there is a formal process and there is a formal set of criteria that the federal minister can take into account when deciding whether or not federal EA should be applied to a non-listed project. None of that detail, none of those important provisions are found in the regulatory proposal. And I think that's a fairly significant omission. So if you're concerned about some of the things that I've discussed, here's your opportunity. This is what you can do in the next few weeks. There is a public comment period that's currently running. You have to get your public comments in on or before November 10th. You should at least take a look at the registry notice for the proposed list. I've given you the notice here. I'll give you the website link in a moment. And you have an option. You have various options for submitting your comments. You can do so by email. You can do so by snail mail. There's a portal that you can use on the registry notice to submit some online comments. The important thing is that you get some comments in. Now, in its consultation materials so far, the ministry has indicated that once they've assessed the public input, then they'll circulate a draft regulation for another round of consultation, and the expectation that might happen in the fall or the winter. And that's all well and good, although I think there's a strong argument saying, well, really, we should be looking at a draft regulation in its entirety right now, because otherwise it's hard to really comment. The other issue that I've mentioned earlier is, we still don't know which projects, if any, might fall under the streamlined EA regulations. Those are the intended replacements for the Class EAs that we have in Ontario right now. So it kind of leaves us shadow boxing in terms of what's on or off the project list, because we don't really know the government's intentions. We don't know if they're going to include them in the forthcoming streamlined regulations or whether they're going to be wholly excluded, in their entirety. So again, it's hard to focus on the project list without knowing the other pieces of the puzzle. And on that point, I'll simply point out that when the federal government went through a similar project listing exercise, it consulted on various regulations before the law was proclaimed into force, so that when the regulations were ready to go, we had a good understanding of what it applied to or what it didn't. Here, the Ontario government seems to be doing it backwards. They rushed through the Bill 197 amendments, and now they're trying to jury rig ex post facto some regulations that make it work. And it's a real muddle. It's a real mess, in my opinion. So let me conclude on this slide. This gives you a few additional resources and some references to check out if you're inclined to provide comments to the Ministry of the Environment. The first link is the actual registry notice for the proposed list. The next item is the Environmental Assessment Act as amended by Bill 197. The next item is a blog on the CELA website about the proposed project list. The next item is a 9-page preliminary review of the project list that CELA prepared a couple of weeks ago. And just in the interest of completeness, I've also provided the link to the 2016 report of the Auditor General, where she deals with certain EA matters that to this day are still unresolved and outstanding. I should also indicate that before the November 10th deadline, CELA will be preparing and circulating a sign-on letter that our friends and allies and colleagues could consider endorsing. We'll also be preparing a very detailed, very comprehensive legal analysis of the project list, and that will go into circulation prior to November 10th as well. So thank you very much for your attention. I see we have a lot of Q&As, 15 at this point, so I think I better stop, and I'll turn it over to April, and we'll start going through the comments and questions. So I
Great.
will stop screen sharing.
Thank you very much, Rick. Yeah, so I will note that in addition to the links that Rick just provided on the last slide of his presentation, we also put in the chat box a link to CELA's casework page around Bill 197, which has the majority of those resources should be on that page. We will also be posting both Carrie and Rick's presentations on our website along with the recording. So if you didn't manage to write down everything that was on those slides as Rick and Carrie were speaking, you'll have access to those.
Okay, well,
before we dive, sorry, just really quick, Rick, before we dive into the Q&A, I just want to take a quick moment to thank both of you very much for your presentations. Just in case we have people drop off during the Q&A, I want to make sure that we thank you both for that.